Laura, your client does not have clean hands here. In this case, there's a much
Your
more.
Honor, you're taking their word against mine.
All
Maybe
right.
they got communication, a letter of September 9th and a
We
letter
never got,
of
you
September
never.
23rd.
Stop! Jesus, stop it. I'm going to set this for a hearing, and we're not going to do it on Zoom. I'll put you all in a room and let you all punch each other, and then you'll all feel better. I order specific performance that Rosemary Blair comply with the terms of the lease with option to purchase. Defendants shall be entitled to application of all other escrow funds. I'm going to continue the escrow order in this court, $2,000 per month. I'm going to order that the defendant purchaser pay the 2023 property taxes. Can you hear me, Ms. Blair?
Yes, thank you.
All right, very good, thank you. All right, we are on the record. And we're going to return to the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. Ms. Blair is here with her lawyer, Mr. Robert Soltis. Also present is Mr. Daniel Hatch on behalf of Joseph O'Donnell and Carla Bowers. All right, I believe we have two matters to address. A motion for contempt regarding the defendant's decision to stop making the escrow payments, and the defendant's motion to release the escrow funds to the defendant. This case was well pled, gentlemen, and I do appreciate that. So, Mr. Soltis, you have the contempt motion, and Mr. Hatch, you have the motion to release the funds. Mr. Soltis, I'll defer to you first.
Thank you, Your Honor. We have another contempt motion. You referenced the escrow, and we also filed for the taxes not.
Oh, yes, yes. Now, it was represented that the taxes would be paid by the time of this hearing. Has that happened?
That they're not paid, Your Honor.
All right,
I spoke with my client this morning, and I can shed some color on why that is, but I don't want to interrupt Mr. Soltis from
All
presenting
right,
his
well,
motion.
then that issue's still on the table as well.
Well, I think the contempt motion's pretty simple, Your Honor. The order of July 31st, 2023 said Mr. O'Donnell and Ms. Bowers were to pay the 23 taxes. Those have not been paid. And then court also in the same order said that Ms. Bowers and Mr. O'Donnell need to escrow $2,000 a month. Obviously in September of last year, Mr. O'Donnell and Ms. Bowers just decided not to pay anymore. And so from October to the present, that's 8 months, $16,000. And Your Honor, if for any reason O'Donnell and Bowers didn't agree with your order, they had many, many ways to do that. And they weren't, nothing was done. They didn't pay, they just didn't do what the court ordered. And, you know, the court gave them exclusive possession, O'Donnell and Bowers. And I believe that the court's order was purpose was to give them incentive. And that is to basically have skin in the game by paying the $2,000 per month. They haven't done that. They haven't paid the taxes. And if I'll get to Mr. Hatch's motion after he has a chance to discuss it with the court.
All right, well, let's assume for the sake of argument, that your argument is compelling for, they just stopped. Mr. Hatch contends that somehow it got swallowed up by the order. granting specific performance, but at some point they just stopped. Now, he did file a motion for distribution of the assets, and I think that was in February, and I apologize, we're not hearing that until now. So yes, it's a violation of the court's order. So if we assume that to be true, what's the remedy?
Well, the remedy is certainly not to give Mr. O'Donnell the $24,000 escrowed already. That money, first of all, should be used for the taxes, because obviously the taxes aren't paid. Then there's foreclosure, possibility of losing the house. And the 23 taxes, according to the county treasurer, is presently $10,428.52 for 2023. Now, 2024 are due as well now, and but the 23, that's the amount.
You had it in your pleadings, but what are the 24 taxes?
24 taxes are $8,993.87. And that would be a total of $19,422.39.
Well, let's do this one first, and then we'll do your other motion.
Certainly. Good afternoon, Your Honor. Dan Hatch on behalf of Joe O'Donnell and Kyler Bowers, may it please the court. I think, Mr. Soltis, we all agree that the 2023 taxes have not been paid, and the escrow stopped at a certain period of time. As we put in our response, the number one, contempt is a willful, intentional act or omission that is made on behalf of a party to the case. This was not willful. This was not intentional. The underlying issue here is that I think that to no fault of the court, or no one caught it at the time that the judgment was entered, there's conflicting provisions in the June 28th, 2023 order or judgment that was entered by this court after the bench trial on our specific performance claim. The order requires, I'll say to the court, it's at paragraph 10, it requires the parties to comply with the lease with option to purchase contracts. The lease with option to purchase contract that the court ordered specific performance of, it's attached to both of our response to Mr. Soltis's motion and my own motion to release escrow proceeds. It's page 1, lease payments. Tenant shall pay to the landlord monthly installments of $0 per month. There are no lease payments under the lease with option to purchase for specific performance. So there was a May order from this court for escrow of $2,000 per month. That was before we had the trial. That has continued. I think that as part of the judgment for specific performance that just got missed, and it's my fault, Mr. Soltis's fault. I mean, everyone's fault for missing that. But really, there's conflicting provisions. Also, with the lease with option to purchase contract at page 2, it states landlord shall pay all real estate taxes, which may be levied against the premises. So again, the court's order for specific performance with the lease with option to purchase requires Ms. Blair to pay the property taxes. I think the bigger issue here, Your Honor, is that what has transpired since this court held a trial on this case and did an efficient and effective job about basically putting out a silver platter to the circuit court is really a travesty. The claims were supposed to get transferred to the circuit court. Mr. Soltis filed a meritless motion to overturn everything that we did in the district court that Ms. Blair didn't like. He did not do it as an appeal. The circuit court has no jurisdiction over that. It was a very simple response to the motion, which is, number one, you did have jurisdiction to do what you did in the district court. And second, the circuit court has no jurisdiction to hear, in essence, this untimely appeal. That has been pending for 617 days in front of the circuit court.
Well, 617 days as of the date of your brief. So it's, or is that as of today's date?
That's of today's date, from the
Okay.
date that Mr. Soltis filed it. So
Okay.
September 7th of 2023 is when Mr. Soltis filed the motion. The case was transferred in July. So in essence, there's been no action in the circuit court. My clients are hanging off in the wind. They're carnage to the system in the sense that We're waiting for a damages judgment from the circuit court, and the circuit court is not acting on that. There's continued delays. There's continued gamesmanship on behalf of Ms. Blair. My clients have a judgment of specific performance, and we're waiting for a damages award to be heard and issued by the circuit court, and that just hasn't happened yet. So during this entire delayed proceeding, now the order of the escrow of $2,000 a month conflicts with the lease with option to purchase. I mean, in essence, as Mr. Soltis argues, it could just go on indefinitely, forever. $2,000 that my clients are paying when they have no legal obligation to pay that, or the property taxes. The property taxes, I have encouraged my clients, not because they're required by the lease to option to purchase, but we don't want the home, the collateral, to go into foreclosure. So they've been working with the treasurer's office over the past week to try to pay those property taxes. Here's the issue. It is a non-homestead property because it's in Miss Blair's name. It should be in my client's name.
Oh, boy.
It's double the amount of the property taxes. So the $10,800, my clients went there with a check to pay the property taxes, and they say it's not $5,800, it's $10,800. So this all goes back to the issue that Miss Blair evicted my clients from the property without cause, will not tender possession of the property or title to the property when we were ready to do it. And this whole mess was caused by Miss Blair violating the lease with option to purchase. So again, there is no intentional, willful dereliction of this court's order. I think that we need to sort out the issue between the lease with option to purchase, the specific performance of that. And we need some clarity for the court about who is required to do what and why. And that's why the taxes are not paid and the escrow payments are not paid. And we'll argue, I'm sure momentarily, about why we're asking them to be released. Nothing further unless the court has questions.
Some of this may be because of this court's naivete or optimism on how fast this would be taken up in the circuit court. You argue in your pleading, the O'Donnell should not be required to pay $2,000 of rent per month to escrow while this dispute is needlessly delayed due to no fault of their own, particularly because the contract orders specific performance does not require them to pay any rent. So the matter was subject to orders in this court in July of 23. And the matter was removed to the circuit court. The court did make a ruling on the specific performance. There were a number of other issues which were by stipulation and fact agreement of the court all removed to the circuit court because circuit court has jurisdiction of those types of equitable claims. So the first hearing was set for September 29th. Okay, now we didn't even get to any of the issues that were removed. It was an argument regarding Mr. Soltis's motion for lack of subject matter jurisdiction. So the court hasn't even ruled on that yet. If he grants the motion, I don't know what happens. If the district court didn't have jurisdiction and the circuit court does, if he denies the motion to deny, he still has to decide all the other issues regarding the damages. So the original hearing was set for September 29th. Because of a scheduling conflict, I don't exactly know what it is. The matter was adjourned to October 10th. And I remember the day the pipes burst upstairs in the courthouse, and through no fault of anybody's, the hearing on October 10th was canceled due to a burst pipe. The matter was adjourned to December 14th. And for reasons I don't understand, then it got adjourned to January 5th. So it was set for January 5th of 2024. So we're all the way from July to January for different circumstances. And then according to the pleadings, the parties appeared for the motion hearing on January 5th. At that time, the circuit court had not reviewed the motion papers and ordered the parties to submit supplemental briefs, set a new hearing date for March 28th. So You still didn't get your hearing, either of you. So now it's set for March 28th, and I can identify, it's hard to get dates. So then you come back for March 28th and the circuit court doesn't take the matter up. It orders the parties to go to mediation. And I never ordered mediation because I didn't think it was gonna work, and it didn't. So the parties went to dispute resolution and made their effort, and they were unable to resolve it. So they have formed the court on May 24th that mediation didn't schedule the matter. So it got adjourned all the way from May 22nd of 2024 to February 20th of 2025. I'm not sure what caused that lengthy delay. So then there was a hearing regarding Mr. Soltis's motion on February 20th. And the court took the matter under advisement on February 20th. So I guess as of today's date, 617 days after the motion was filed, we still don't have a ruling. I checked with the clerk. The ruling's not forthcoming. There's some other things that he's working on. And as I said, even if he denies the motion, you still have to take up all the issues that were removed to circuit court, not the least of which is the damage hearing. And you just raised an issue that none of us saw. I talked about interest rates going up dramatically from the time when this contract was to be entered until now. And none of us had the presence of mind to realize this was a non-homestead property. Mrs. Blair lives in Crown Point, Indiana, and this property's in Michigan. The O'Donnells also have an address other than this. The O'Donnells, as I understand it, wish to make this their primary residence. So, and this is a LT case. This is a landlord-tenant case, not a general civil case. And so I made a ruling on the specific performance, and I ordered, as I often do, escrow payments. And Mr. Soltis was right. It puts some skin in the game for the defendant. But under my naivete, I didn't think it was going to take 3 years to get to that point. We're not there yet, and it doesn't appear we're even close. I also ordered that they pay the taxes. Now, the payment, and it's in the pleadings, was under the assumption that if the specific performance was granted, those proceeds would be applied to the purchase price. So essentially, if the O'Donnells prevail, they were making a monthly payment each month. And if they prevailed, then that money went to Miss Blair as part of the purchase price for the house. If they did not prevail, then there were some decisions that had to be made about what happened to that money. But the purchase price was $450,000. The damages, I think, would argue to be offset the purchase price. So for example, if Judge Stutzman found that the O'Donnells were $50,000 in damages, I just pulled that number out of the air, that would reduce the price by $50,000. So in September of 2024, Tabitha Wedge, our district court administrator, spoke to that escrow payments. They made 12 payments of $2,000 each for $24,000. As the district court is no longer has jurisdiction in this case, the $29,000, the original $5,000 down payment, the 12 $2,000 payments were transferred to the circuit court for escrow payments. So it was after September, it was at that point your client stopped paying. Is that correct?
I believe so.
I think it was September was the last payment.
I have a ledger from the district court, and that's what I really can't understand. I tried to have my clients get all of the payment history, but I don't know if he has made payment to the circuit court? Because at a certain point,
No,
the
I
escrow
don't,
got,
I think once you got this letter, the payments stopped.
okay.
I don't believe payments have been made to the circuit court. So there's even a question, Mr. Soltis, whether I have the authority over this. Right now, it's sort of a lose-lose proposition pending a decision in the circuit court. If the O'Donnells were to rent this house, I don't know, in this rental market, it would rent for $2,000 a month. If they were to purchase the house, I don't know what their plans were. I think when the interest rates were very low, I think their plan was to borrow the money and pay at 3.5% interest. Now that interest is much higher than that, I'm not sure what their plan was, but I'm not sure their payment would be $2,000 a month if they were to take out a 30-year mortgage. So it's expensive. It's well more than the rent was, because the rent was zero, based on the theory that at some point this property would go forward. But Miss Blair gets no benefit of this $2,000 a month. The $2,000 a month that was paid went into it's in the treasury of St. Joseph County. So she gets no benefit of it. She doesn't have the benefit of the use of the property. I'm assuming that the O'Donnells are paying the utilities and using the property. But I thought, all right, we'll get a hearing in September or October and this will be done. But without, as Mr. Soltis indicated, without consent of this court or the circuit court, they just stopped paying. That is willful. And I wasn't even aware they had stopped paying. Again, things have been transferred to circuit court, and the circuit court clerk didn't call and say, hey, they didn't make their escrow payment. Had it been here in district court, our landlord tenant clerks, there are actually three, maybe they have a hand in this. One of them, Lisa, was all over this during the time of it, and she was really on top of it. She probably would have come and said, hey, we didn't get the escrow payment, but it was transferred to circuit court. So I do find it's a willful violation of the court's order. The taxes are more complicated. As a practical matter, I don't know whether this would be a homestead property for the O'Donnells or not. It is not, these taxes are expensive. And nobody wants this house to be foreclosed on. So I find there is a willful violation of the court's order. The question is, what do I do? I have not discussed this with Judge Stutzman. The case is before him. And I did discuss it, sort of bounce some ideas off Judge Pattison, my district court benchmate. I don't know that I come to the answer to that question. I do know we need to get the taxes paid. Now, to throw a further wrinkle in this, you're asking me to release the escrow funds to you, to the defendant, Mr. O'Donnell, and that was never my intention, that he'd pay 12 months of escrow and then I just give it back to him. Mr. Soltis makes a suggestion that perhaps you use the escrow funds to pay at least the 2023 taxes. But frankly, I don't think this matter's going to be resolved by the end of this year, which means the 2024 taxes, we have $29,000 in escrow, and we have $19,000 worth of tax that needs to be paid. If the O'Donnells prevail and my order stands, but for specific performance, they get the benefit of having had their taxes paid. If for some reason Judge Stutzman views it differently, and then Miss Blair has the benefit of having had her taxes paid. As a practical matter, the O'Donnells are living in it. They've been in there in 2023, 2024, had the benefit of the enjoyment of this house at Quarry Lake. And presumably will have the same enjoyment in 2025. It stops raining. And Miss Blair is frozen out of her property. I don't know what progress, if any, was made at mediation. Mr. Hatch, what's your response to Mr. Soltis' suggestion that this escrow funds be used to pay the taxes?
Your Honor, I would just go back to the bigger issue that's under the court specific performance order. Miss Blair is required to pay the taxes and she's required to receive no benefit of no lease payments.
That's
So-
not true. My order says the defendant is to pay the taxes.
That's correct.
The lease or that screwy purchase agreement said she's to pay the taxes, but my order said that the defendants are to pay the taxes.
And I think that in lies, and again, I absolutely respect the court's order, that in lies the confusion between one of the paragraphs, paragraph 10 says, defendant counter plaintiff shall otherwise comply with the terms of the lease with option to purchase. So you look to the terms of the lease with option to purchase and it says, Miss Blair is responsible for the taxes and receives, and remember, my clients have already paid her $107,000 that this court has found.
Yes.
So, and then you juxtapose that with the other parts of the court's order. It says there's a $2,000 per month escrow payment. But again, that came from an order in May before the June order of this court, where we hadn't gone over and a specific performance wasn't awarded. So it's just, there's conflicting provisions, Your Honor. And I understand, again, everyone wants to respect the court's order. But under the lease with option to purchase, she is required, which the court ordered specific performance was, she's required for the taxes and gets no rents. I think everyone here wants the taxes paid. But my clients at a certain point, they have been so caught up between paying $112,000, litigating what I would say is probably the most expensive landlord tenant case, not because of this court's fault or anyone's fault here, but because it was bifurcated to the circuit court. We've been waiting. I mean, they have paid a significant amount of attorney fees to just regain possession of the property.
Well, I saw that clause in there where it said the court had not reviewed the pleadings, directed the parties to brief the issue. I thought, well, I wonder how much that cost.
We came 3 different times to the circuit court on a what I would say is a baseless motion. And if that motion gets granted, it's going straight to the Court of Appeals. So the circuit court does not have jurisdiction to hear. The way it works is that if someone doesn't like what the district court does, you appeal it. And there's a court rule, it's 700, that says, here's the time limit so when you need to do it. And you go to the circuit court under an appeal. There's a specific form you have to do. It's an appeal that's like the Court of Appeals, but from the district to circuit court. Mr. Soltis didn't do that. He just filed a motion to vacate all of the orders that negatively affected Miss Blair. So again, more time, more delay for a baseless motion. We've got our order from this court that this court put in a very nice package to the circuit court, and nothing has transpired since that time. So they paid $107,000 to Miss Blair to get the property that they were entitled to in the first place. They have tens of thousands of dollars. I don't want to tell the court how much in attorney fees that they have at this point in time. And they have got no justice in the circuit court. Like I said in our brief, justice delayed is justice denied. At a certain point, I think it's Miss Blair's contention that I'll just wrap them up and kill them through attrition, through the process of the court. And if they're required to pay more property taxes that she's required to pay under lease with option to purchase and keep paying rent payments that she's not entitled to, that might happen. Because at a certain point, they're going to say, we paid $107,000. We're paying all these attorney fees. We now have to pay property taxes that we were never going to pay in the first place, and an additional $2,000 per month in infinity until the circuit court makes a decision. And if they make the wrong decision, it goes to the Court of Appeals, and then they keep paying the escrow payment. So it's an impossible predicament.
Well, my vision would be if they prevail in my specific performance order, the property taxes would be reduced from the sale price under your damages claim in circuit court.
I think
And
that's
so it's not like they're paying now. If they pay the property taxes and they prevail, they get credit on the purchase price for the taxes. If Mrs. Blair pays the property taxes, then that would not be credited against the sale.
That's correct.
And so it's like, who pays now? But we haven't even got Mr. Soltis's motion decided. I think there's 8 issues that are before the circuit court, the equitable issues that were part of this claim. And those are tough things. I guess maybe Judge Stutzman's thought that perhaps the parties could come to some settlement had merit, but they haven't. And it's expensive to not do that. And that's sometimes what happens. The court moves so slowly, and I'll put myself in there with the court, that it is easier for the parties to just work something out. All right, so why should I give the money back to your clients?
There is a provision in the order, Your Honor, that says the defendant counter plaintiff shall be entitled to application of the escrow funds currently held by the court. That is because, and I think the way this all transpired was, my vision is that there was an order in May of 2023 before this case was tried before this court on a bench trial. And it makes sense. I mean, if someone's in a property, you typically order escrow payments of
Yes.
monthly. So that came, and then we had a bench trial. And then the court ordered specific performance of the lease with option to purchase. I am as guilty as everybody else that when that was ordered, it conflicts with the specific performance order. Because if you look at the lease with option to purchase, they're not required to pay any rent and they're not required to pay the property taxes.
And I was aware of both of those things. And that would be even worse if there was nothing. And the idea was the rent was zero, that she was going to pay the property taxes, and sometime within a certain date, within 90 days, they were to come up with a payment and close the deal.
Yeah.
And they were, I believe from the testimony, they were prepared to do that.
And they were ready to have their children move in and they were going to make it their full-time residence. They had schools ready to go. All of that happened, right? And exactly what this court said, I thought this would be very quick. A transfer, we have liability established, there's a specific performance order. All the circuit court had to do was decide the damages with respect to one hearing about to offset the purchase price. That should have been, that could have happened within 60 days. 617 days have transpired and the court hasn't even entertained. I haven't taken any depositions. There hasn't been any hearing on that because Mr. Soltis filed a baseless motion saying the district court had no jurisdiction to do what it did. And again, those delays then prolonged 2,000 a month, 2,000 a month, 2,000 a month, now 2 years of property taxes, not 2023 to 2024. My clients don't have the financial wherewithal to keep going through that. And I think that's at a certain point in time when they saw the conflicting orders between the specific performance or lease with option to purchase and the $2,000 a month, they said, well, we're complying with the order. We're not required to do this. And then everything just happened and really nothing happened. So what I would say, Your Honor, is that really there was the May order for escrow that was superseded by what I see as the specific performance order. My clients are not required. I mean, the reality is that if they don't make the $2,000 a month payment and they don't come up with the money, Miss Blair keeps the $107,000. That's the skin in the game for them. So to be continuously contributing towards that payment, which they have no legal obligation to make under the contract, seems to be not benefiting Miss Blair at all. She doesn't get the money. It hurts them. And there's no requirements. And then the property taxes, Miss Blair's the landlord. It's a lease with the option to purchase. The tenant typically doesn't pay the property taxes, and it actually says in here the landlord pays the property taxes. Two more things I want to add, Your Honor.
Well, let's make that point again. Right now, their tenancy is under the color of the lease. I've granted specific performance, but it's been held in abeyance by Mr. Soltis' motion for rehearing. So they're not trespassers. They're on a lease, which granted was a screwy lease for zero rent, and she paid the property taxes. I wanted, as Mr. Soltis said, it's a landlord-tenant case. You'll set up an escrow payment, and usually they aren't this large. Rent's $900 a month. The tenant challenges the habitability of the premises. I do a $900 per month escrow order, and we resolve the case in 2 months.
Right.
And I did that, you're right, in May, before we had the hearing in July.
And this is different, really, I don't mean to interrupt, Your Honor, but this is different because typically in a normal escrow order, the tenant had not already paid $107,000. They've in essence prepaid years of rent by the payments that they've already made to Miss Blair. So again, that's another distinction. You know, they're piggy bank here, and they paid Miss Blair the money. She has not allowed them to be in the property. The court fixed that issue. And then now she's saying, keep giving me money and pay my property taxes until the circuit court does what the circuit court will do. And we find out how much money, if any, is owed to her under the purchase price. And to convey possession of the property and title of the property to my clients, if they choose to get a loan to close on it.
Well, right now, Miss Blair isn't getting a penny.
Right.
She's not getting the benefit of the $29,000 it was paid. And she's not getting the taxes paid. And had the sale gone through and the O'Donnells made this their primary residence, they would have been eligible for the homestead exemption, and the taxes would be much less. So we're talking, before we're done, probably tens of thousands of dollars difference. I don't think the answer is releasing the money to the defendant. We've got several options for it. Mr. Soltis, what's your response?
My response, Your Honor, is talk about baseless motions.
Yep, no problem.
Mr. Hatch's motion is definitely baseless
Well, the motion to give them the money back?
to release.
Yes.
First of all, it doesn't make a whole lot of sense. Number two, there's no reference to any legal principle, case law, whatever, that would support.
Well, your brief said, I don't cite any authority because nobody cited me any authority.
Right, so there is no authority for them to get this money back. And Your Honor, we've kind of talked around it. If you have the actual lease option, which Mr. Hatch says, well, that says landlord shall pay all the taxes. And in one section it does. In another section, it doesn't. It says the tenant shall pay the taxes. And this was a contract that was drawn up by Mr. O'Donnell.
What paragraph are you referring to?
The maintenance section, I believe it's on page 2, halfway down.
Maintenance. Landlord shall have the responsibility to maintain the premises in good order at all times and perform all repairs necessary to satisfy any implied warrantability or habitability, except that tenant shall be responsible for taxes, electric, gas, water. Standard upkeep of repair. Tenant must notify the landlord within 24 hours of any condition requiring maintenance. Landlord shall pay all real estate taxes which be levied against the premises. Oh boy. Yeah, it looks like they didn't really want to put taxes on that line, but they did, and so that's what it says. So you're right, in one paragraph, it says the tenant shall pay the taxes. The other paragraph says the landlord shall pay the taxes. Now, things were supposed to happen. This is a lease with an option to purchase. The parties have paid Rosemary Blair $85,000 of the $450,000 purchase price. The parties have agreed that the tenant's purchasers will have a reasonable time to secure the remaining $365,000 for purchase. Rosemary Blair shall also be granted reasonable time to get her finances in order. And this is what was supposed to trigger it. Once Rosemary Blair informs Mr. O'Donnell and Miss Bowers she's ready to close, the purchaser shall have 3 months, 90 days to close. In the event that there is an unforeseen delay for any reason, the purchaser shall pay $1,000 per month. So there was sort of a built-in escrow until finance is secured. This agreement includes all real and personal property and surroundings. And then down at lease payments, defendant shall pay to the landlord monthly installments of 0 on the first of each month. So it was clearly envisioned that this was going to happen quickly. It was signed in way back in November of 21. Then, does anybody have an opinion whether I even have authority to deal with this? District court is no longer a jurisdiction of this case. The $29,000 have been transferred to the circuit court. And so all the damage issues are in the circuit court. Heaven forbid, if we throw one more thing on the pile in circuit court, I'm not sure what that means.
Judge, in full transparency, I think that you do have jurisdiction. There was an issue with, I think the circuit court thought all the claims were transferred up to the circuit court. If by the order of transferring specific claims, not all the claims were transferred to circuit court. You retain jurisdiction over specific performance, summary proceeding, which you would have to because you have exclusive jurisdiction over it, and quiet title.
All right.
So you do have those 3 claims still down here. And that was clarified with the clerk's office because in the order transferring it, we said the specific claims that were transferred, but we didn't specify the claims that stayed down here. But I do believe that you, in full transparency, do have jurisdiction over those 3 claims and then the order you've entered in this court.
Mr. Soltis, anything you wish to say? You're still there at the podium. But yes, you pointed that out, and I've probably read that agreement 20 times from the beginning till now, and
I may have missed it in the beginning too, Judge. But on closer examination, it is what it is. And Mr. O'Donnell prepared this agreement. Now, if there's ambiguity in a contract, the general rule is that it's had to be held against the drafter. In this case, Mr. O'Donnell. I'm not sure this is an ambiguity as opposed to a direct conflict. And yeah, I don't know if we should, I don't think we need to have a trial to make that determination, because then we'd have testimony and parole evidence would be appropriate. But the long and short of it is we're just talking about your order of July 31st. And counsel says, well, because you granted specific performance, that somehow abrogated the escrow order. Well, specific performance was number 1. Down the page was the specific, was the 2000 escrow. Same order. So the long and short of it is, Your Honor, you ordered this. And apparently they believed you had jurisdiction. And second of all, they never even raised this up. They paid $2,000 a month for maybe 24 months or 12 months, and then stopped altogether. And they could have very easily come back to this court and said, hey, listen, we don't think you have jurisdiction, or maybe this is too high, you should modify it, or any kind of motion. They just let it go, and then they stopped paying. And that's what we're here for, is because you made that specific order. Just like you made the specific order that day to pay the taxes.
well, if you hadn't filed the motion, I wouldn't have known it.
Right. And I didn't know it until I checked. And the bottom line is Mr. O'Donnell and Ms. Bowers have not lived in the property. I mean, I don't think they can get a homestead exemption anyway, because they both have 2 houses, as they testified in front of this court. So they're, and they've never stayed there. They haven't taken care of the property. The property is going to.
Now, I don't know any of that.
Those are misrepresentations.
Well, they certainly have right to exclusive possession of the property. And, this was real people. Their kids got put in different schools. It was very stressful on their relationship. It was, a financial hardship. She had to go back and live with her parents. It was very disruptive to everybody's life, Miss Blair's and theirs. They simply want to complete the purchase of this house for the agreed upon price of $450,000. What does your client want?
Well, Ms. Blair wants to sell the house because she's agreed to that. 450,000 minus the 107,000 that this court already held, minus whatever they would get maybe in circuit court, and the escrow money. That would all be applied, and that would reduce the amount.
All right, so you simply want a ruling from the circuit court that says how much damages are so they can complete the sale.
Well, I think everyone agreed on that.
Everyone agreed on that until Mr. Soltis filed a motion saying that the district court doesn't have jurisdiction.
Well,
Your Honor, that is a complete misrepresentation.
I haven't reviewed the motion, and fortunately, I'm not going to be the one that has to decide it. But according to your representation, you essentially want the same thing they want, is a decision from the circuit court as to how much. Miss Blair, are you 84 now?
Yes,
Um,
I wished I could talk once and I've never been able to. And I'm very frustrated.
all right, well, you're not giving testimony at this point. We're just doing argument. Yes, I know you're very frustrated.
Beyond belief.
But there's enough frustration to go around. I think we've all got plenty of it.
Your Honor, all we're asking is that you enforce the order that you made on July 31st, 2023, 2,000 a month. And they pay 23 taxes. And just to clarify, or actually tell the Honor that Mr. Hatch's representation to the court that I filed a motion that says you don't have jurisdiction. I said, no, the court, you didn't have jurisdiction over the claims that were in excess of 25,000. That's the only motion that's in front of the court of circuit.
All right, well, we'll leave that to them. Okay, I've got a solution that probably isn't ideal, but I want to keep this case moving. I was looking for just a conclusion to this thorny, difficult issue for the O'Donnells and for Mrs. Blair. I was trying to get the case to the finish line, and there was a lot of headwind we went against, but I made a ruling. The defendant is not in compliance with my ruling. I do agree with Mr. Hatch that the court has retained the summary disposition, summary proceedings portion of this. So this may be kicking some of these issues can down the road. I'm going to order that the 2023 taxes of $10,428.52 be paid from the escrow funds currently held by the circuit court. That can be sorted out when the property is sold. Either it'll be deducted from the sale price or it won't. Judge Stutzman can determine that as damages. I find the defendant has violated my escrow order, but I don't know what the proper sanction is. The tenant agreement that they had was if things went sideways, they would pay $1,000 per month. So I'm gonna enforce my escrow order, but I'm gonna amend the amount to $1,000 per month commencing May 2025. I'm reducing it by half. I'm not doing any sanction for the money that was missed. Miss Blair doesn't get this money anyway, at least not yet. She certainly, I'm sure, could use $2,000 a month. And she could certainly use the proceeds from the sale of this property if we could ever get it sold. So the agreement is contradictory, the original buy-sell agreement. One portion says the tenant shall pay the taxes. I think that's a mistake. But as Mr. Soltis indicates, the mistake goes to the drafter. And then it also says that the landlord shall pay the taxes. I ordered that the defendant should pay the taxes. And we'll use the escrow money to do it. And then the escrow order will commence beginning this month, $1,000 per month, paid in escrow to the circuit court clerk. I don't know when your ruling is forthcoming regarding the jurisdiction issue. If you prevail on the issue, Mr. Hatch, there's still all the other issues. You guys had hoped they would be simple. One thing you could do is if you could come up with a figure between the two of you, this is what we believe the damages are, Judge Stutzman. We would like you to order damages in this amount, and then we can execute this sale. I believe my ruling, the defendant complete the sale, was appropriate. I'd like to see the case move forward, but for purposes of both motions today, your motion to release the funds to the defendant is denied, but they shall be released to the clerk to pay the 2023 taxes. Now, 2024 is still looming, but I'm not going to make a ruling regarding that pending the circuit court moving forward in this case. But my fear is you guys aren't going to be back in circuit court for a number of months. And I haven't been out there. I have family at Quarry Lake and I've seen the property and but I haven't seen it in a couple of years. But life goes on. Their children are getting older. They may have changed jobs, or I don't know what the nation of their relationship is. Miss Blair's had 2 more years pass in her life, and this property's sitting there. I hope it's not got foot-long grass and raccoons in the eaves, but they should have some skin in the game, and right now there's none. So $1,000 a month starting May 1st. We're going to use the escrow money to pay the 2023 taxes. I wish you all the best in circuit court, getting a hearing date and getting some things. I certainly sympathize. These aren't easy issues, but the parties want to bring this to a close, and I don't blame them. All right, thank you.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank you.